Today, so let's go ahead and talk about why do people how do you prove somebody has made a false confession? There's 4 ways to do it. The first way is that a suspect could confess to a crime that never happened. If they say they murdered Abraham Lincoln, well, maybe they didn't, because that was John Wilkes Booth, of course, and that was also 150 years ago. So that's not going to be true. Or they said that they murdered Donald Trump. And of course Donald Trump's still alive, so obviously that would be incorrect. It was physically impossible for the suspect to commit the crime. They were here and Donald Trump was in Washington, D.C. That's physically impossible. Let's not talk about the president, okay? Let's talk about somebody else.
I was going to say supernatural.
Yeah, let's kill somebody else. The actual perpetrator is identified with guilt objectively established. In other words, we know who did it. This individual, the DNA is there. We have other evidence, possibly they've confessed. There were eyewitnesses that saw this other individual do it. In those cases, of course, the false confession is not going to work. There is evidence such as DNA evidence. This is number 4. There is evidence, DNA evidence that definitely establishes the defendant's innocence. And of course, that's the other way that we can prove that it was a false confession. Interrogation is really an art form. One of the things that they do before they interrogate somebody is they soften them up. When a suspect arrives at a police station for questioning, the police begin to subtly exert pressure on them to talk. The interrogator may try to soften up the suspect by using flattery, by ingratiation, or rapport building. You know, you and I are buddies, so let's have a good conversation here. Wow, you're really smart. I think you're probably a lot smarter than any of the police here. Okay, what we're doing is we're flattering them, we're setting them up. We're trying to get them off balance by flattering them. You know, you're so much smarter than I am. There's just no way I'm ever going to get you to admit that you committed a crime. You ingratiate yourself to them, you flatter them, and potentially, eventually, of course, they will disclose some information that they don't mean to disclose because you're taking them, you're making them off balance. You might ask them benign questions and engage in pleasant small talk, and this, of course, gets them off balance. The police are required to give the Miranda warnings prior to questioning, but there are ways to circumvent the Miranda warning. Warnings are required only when the suspect is being interrogated. So if you're not interrogating the suspect, you can talk to them all day long and you don't have to read them your rights. Their rights. Just because you are a policeman and they are a potential suspect doesn't mean that you have to read them the rights. If your father were a police officer, when he comes home, he wouldn't have to read you your rights every time he came home, just in case you disclosed some information to him that you shouldn't have disclosed to him. Warnings are required only when the suspect is being interrogated while in custody, so police sometimes tell the suspect that he is not under arrest and is free to go. So there's no need to warn this individual. It's not an official interrogation, so you don't have to read them their rights. And then you just have a conversation with them. And sometimes they will disclose information that they shouldn't have disclosed. And since you haven't read them the rights, and since they're not being interrogated, whatever they say to you, of course, is admissible in a court of law. If Francis and I were having a conversation and he disclosed that he shot my dog, yeah, I know. Of course, I'm not a police officer, but you shot my dog, and then I told the police that you admitted that you shot my dog, then we could go to a court of law, and I could say, well, he told me that he shot my dog, and as long as he was telling the truth, then he shot my dog. And even though that's secondhand information, it's still the fact that you disclosed to me that you did that. Sometimes the police will minimize the importance of the Miranda warnings by describing them as a mere formality. When Miranda warnings are provided, almost all suspects waive their rights to talk to the police. This is one of the reasons why on television you so often see people being interrogated. They've waived their rights. If they are sitting in that interrogation room, then they have waived their Miranda rights. Especially if they're sitting in the interrogation room without a lawyer, then they've waived their Miranda rights. The police use negative incentives such as accusations, evidence fabrication, attacks on the subject's denials to break down the suspect's defenses, lower his or her resistance, and instill feelings of fear, despair, and powerlessness on the individual. So they're breaking them down. The police also use positive inducements to motivate the suspect to see that an admission is in his or her best interest. They can say anything they want to you. They can threaten you with anything that they want. They can say anything. That's the reason why you should have a lawyer in the room, because a lawyer knows what's legal and what's not legal. They can lie to you. They don't have to tell you the truth. If there's two of you that potentially committed a crime, they can tell you that the other person confessed and that person said that you did it. They can lie to you. There's no law that says that policemen can't lie. Just to get you to admit the crime. After the suspect has implicitly or explicitly agreed to talk, the interrogation becomes accusatorial. Interrogators frequently challenge denials that suspects make. Interrogators present fabricated evidence. Really? They can do that? Yes, sure they can. Even if interrogators have no evidence of suspects' wrongdoing, they can make them believe that they do. They can do anything they want. They can lie to you all they want. Just recently, a newspaperman from the Washington Post was interrogated by the Saudi government. And during interrogation, they did something to him and he died. And then they chopped him up into little pieces to get rid of him. I know, what's going on here? It was the Saudi government. And this is a huge deal. I mean, it's huge. This is a newspaper man. And they murdered him during an interrogation. So what's going to happen next? I don't know. I don't know what's going to happen next. Well, Trump doesn't. They're his friends. So of course they didn't do anything. Obviously they didn't do anything wrong because they're friends of his. And that is the criteria that we use. Are you a friend of Trump's? So we'll see what happens. I keep saying that, don't I? This is really kind of irritating to me. I would like to scream from the rooftops. This isn't right. We're murdering newsmen now. Well, they're murdering newsmen. He was also a Saudi citizen. And theoretically, one of the princes, there's like 2,000 Saudi princes. Well, one of the princes was in on the interrogation. So we'll see what happens. Hate to say that. Because nothing ever happens and people just forget it. I hope everybody's signed up to vote in the next election. Mm-hmm. Huge. This is a huge election. This is gigantic. This is massive.
I think even the senators are debating.
Was that right? The two ladies?
Arizona senators?
Two ladies? That ought to be interesting.
One of them, I think, misinformed or miscorrected herself or something.
Okay, which one was it? Was it like Sally or was it Cinema?
Cinema, I believe.
Oh, it was Cinema?
She said something and then they took it the wrong way and then something about
because Cinema's the Democrat and Sally is the Republican.
With the trees in the middle?
I believe that one, yeah, that the subject of the treason.
Okay.
Oh, I read that on CNN. Something about treason. Now they're making, I don't know, I don't get Arizona television. All my television comes from New Mexico.
That's so stupid, right?
I don't know. It doesn't matter to me. I vote in Iowa. And I've already voted. Okay. Well, we'll see. Like I keep saying, we'll see what happens. An empirical look at interrogation tactics. Innocent people are more likely than guilty people to waive their Miranda rights. And this is one of the reasons why everybody waives their Miranda rights. If they are innocent, they're more likely to not need a lawyer in the room. They should be able to answer questions if they're innocent. Detectives' presumption of guilt can lead to behavioral confirmation. The detective will seek out information that verifies that belief, overlook conflicting data, and behave in a manner that conforms to the belief. In turn, the suspect behaves in ways that support that belief. In other words, if they treat this guy like they're guilty, then the detective, everything that the detective does will aim toward proving that person's guilt. And of course, since the detective is asking questions in that direction, then the suspect will actually behave in that manner. So if they think that he's guilty or she is guilty, then they can force it to look like she is actually guilty. And she will start acting like she's guilty. Many juveniles have difficulty understanding the rights accorded to them by the Miranda warnings. Of the 125 proven false confession cases compiled by Drizzen and Leo, 33% involve juveniles. Juveniles their brains aren't quite mature yet. Remember, before your brain becomes mature, the process of thinking goes through your amygdala before it goes through your prefrontal cortex. Prefrontal cortex is where all your reasoning takes place. Amygdala is where all your emotions are, and this is one of the reasons why teenagers are so emotional. They fall in love so easily, and they're madly in love with this person. They're going to stay with them for the rest of their lives and into eternity. My God! We already talked about. Did we talk about love in here? Did we talk about love? Yeah, we talked.
Or when you ask them to do something, they're just like, ugh. That's what I'm dealing with right now.
You're dealing with love? I'm so sorry.
No, with my son being, well, at first it was my
Was he
daughter
in
with
love?
the attitude, no. It's just the attitude of not wanting to do anything.
Right.
So when I ask my daughter to do stuff, she's like, you know. So now that she's gotten out of that, my son's starting that too.
Oh.
So I was just like, come on, guys.
Oh, jeez. Teenagers are so hard to deal with.
You're like, come on, dudes. And they're just like, whatever.
That's terrible. When I married my first wife, I was badly in love, and I was going to stay with her forever, no matter what.
Mm-hmm.
As soon as I turned 25, I realized, oh my God, I don't even like her. Not only was I wrong, I was dead wrong. I almost was dead wrong. She stabbed me in the chest. I know. When did I divorce her? Wait a minute. I married her when I was 19. And I divorced her when I was 24. So there you go. I was just a stupid adolescent when I married her, and by the time my brain matured, I realized how much I didn't really like her very much. There you go. Okay. Kasson and Reitzman in 1985, and Reitzman is the guy that wrote your book, devised a taxonomy to describe three kinds of false confessions: voluntary false confessions, compliant false confessions, where the suspect complies with the interrogator's demands to make an incriminating statement, all the while knowing that he or she is innocent. And the last type is internalized false confessions. As a result of manipulative interrogation, suspects confess because they have come to believe that they have committed the crime. They have convinced them that they have committed the crime, despite the fact that they didn't commit the crime. Many prosecutors assume that only guilty suspects confess, so they tend to treat confessing suspects harshly. For example, requesting higher bail. Even defense attorneys assume that people who confess are guilty and urge them to accept plea bargains rather than risk their chances in a trial with confession evidence. So even if they're not guilty, if they've made a confession, then their defense attorney will suggest that they plea bargain, because if there is confession evidence out there, they're more likely to get a harsher sentence. In cases of disputed confessions, judges almost always decide that confessions are voluntary and thus they're admissible in court. The judge has the right to throw out anything. He can throw out any piece of evidence that he wants to, that he feels is inadmissible. The problem is that if he does throw out evidence that should have been used in the trial, then he can lose in appeals. And of course, judges don't like to be told that they did something wrong. So they can lose in appeals, and of course then they have to retry the case, and it makes this judge look stupid or incorrect. And of course, judges are pretty arrogant, as we saw with Kavanaugh. Got pissed off, blamed the Clintons, which I found really fascinating. He's a judge. He has no proof, and all of a sudden he attacks the former President of the United States and the former Secretary of State in his statement. It was just amazing. And he's a judge. And so what's the first thing he did? What was the first thing that Kavanaugh did? He threw out the Indian Protection Law for Child Protective Services. It's the first thing he did. It's not just for you guys, it's also for any minorities. But that's the first thing he did. It's amazing. Wow. Jurors are very influenced by confessions. Jurors are highly likely to convict defendants who have confessed even when the confession is false. Cases in which false confessors pled not guilty and proceeded to trial show that jury conviction rates of 73% to 81%. So even though they're false confessions, they still convicted at a very, very high rate. Jurors fail to discount a confession elicited by high-pressure tactics of interrogators, and this is because of the fundamental attribution error. If he confessed, then he is guilty. That is the attribution error. They do not see the external situation as a determinant of the behavior. So sometimes they confess because of the coercion from the detectives. And of course, this shows him pulling his hair, but of course, you're not allowed to touch the person that you're interrogating. This is a mock-up, of course. Recording all police interrogations can provide a complete, objective, and reviewable record of how the suspect was questioned. Recording can deter manipulative tactics by investigators and frivolous claims of coercion by the defendants, as long as there is a tape of the interrogation. Then they can prove that this didn't happen. For both sides. This is important for both sides. Unfortunately, all states don't have the same laws, and they don't have the same rules. So not all states record interrogations. Any guesses as to which states don't have recordings? Any guesses? Which ones don't force you to record your interrogations? Southern states. Yeah, there you go. There's a shock for you. Mississippi, Alabama, Louisiana, Arkansas. It's too expensive. It's too expensive. We don't want to spend any money. We'd rather send innocent people to jail. A handful of states require videotaping, and a growing number of jurisdictions voluntarily record interrogations. Most of these are in the north. Most of them are in urban areas. So places where you have large urban areas like Illinois, Ohio, Indiana, Pennsylvania. All of these require interrogations to be recorded. Note that Lassiter and his colleagues in 2009 found that when the camera is focused on the suspect, observers are more likely to judge the confession as voluntary, compared with the same confession recorded from a different camera perspective. So it really all depends on where the camera is. And I don't know if you've ever seen it on television, but the reality is it's usually up in the corner, and it's aimed at the suspect. So the interrogator is very often not even in the picture. It's usually shooting over his head, or her head, whichever the case may be. However, one of the things we're going to discover is if we show both the interrogator and the suspect, if we show both of them, then they're less likely to accept the confession. As confusing as that. That's not that confusing, because they can see their faces. We know what look is on this person's face. So a better place for the camera would be over here at the same level, so that we can at least see them. We can at least see their faces. In this case, we've got two interrogators and one suspect. This is an example of illusory causation, the tendency to attribute causation to one stimulus because it is more conspicuous than others. In other words, if we're just looking at the suspect's face, we're more likely to convict him. When the recording shows both the suspect and the interrogator, observers are more attuned to situational pressures exerted by the interrogator because they can see his face, and therefore they are less likely to convict. Another reform would be reconceptualize the fundamental nature of police interrogations. Researchers have found that the non-confrontational UK-style interviews produce fewer false confessions and more true confessions than accusatory interrogations. Has anybody ever seen the UK style of interrogation? If you watch PBS, they have English cop shows on. It's really kind of interesting. Their technique of interrogation is totally different. It's non-accusatorial. They're just looking for information, and because of that, they get far fewer false confessions or false convictions, because they're just looking for information. It's really kind of fascinating. It takes like 3 times as long, but it's really kind of fascinating. So if you ever see any of the English cop shows, watch their interrogation technique. It's really fascinating. It's takes much longer, but it also gets much better information. It's not nearly as accusatory. And that is the end of chapter, whichever one that was. 7? I know, I'm just excited too. Chapter 8. I'm only a week behind. This is the 9th week. When are your papers due? The beginning of November? Those of you who studied your syllabi, obviously I didn't. They're due in November. Whoops, wrong page. Whoops, go backwards. There we go. No, that's not right. That can't be right. That's right. Okay. Chapter 8, traditional prosecutions, arrest, bail, plead, negotiation, settlements, and trial. Okay, let's take this person to trial. We've already interrogated him, and we've decided whether we're going to convict them or not. We're going to put them in a court of law. Many criminal cases are simply dismissed for lack of evidence or other difficulties that prosecutors perceive in the case. The reality is it's the prosecutor that decides whether he's going to bring a case to trial. Prosecutors that lose cases, prosecutors that bring cases that are frivolous, usually are not elected the next year or the next time they come up for election. So prosecutors like to only take cases that they can get convictions on. The more convictions they get, the more likely that they will be re-elected in the next election. This is one of the reasons why the police are very, very sensitive to collecting evidence. They need only good evidence. So if you watch it from the cop's perspective, and of course we've all seen those television shows from the cop's perspective, they're always looking for good evidence. And it has to be good enough evidence. And then they take it to their captain, and their captain says, oh, he'll never prosecute without better evidence. So then they go out to find better evidence. So the reality is they may know who the bad guy is, but they don't have enough solid evidence to convict. So we need evidence, we need good evidence. For the vast majority of people charged with crimes and not fortunate enough to have charges dropped, plea bargains, not trials, resolve the case. So most of these don't even go to trial. Now, of course, on television, it looks like all the cases go to trial. Why? Because it wouldn't be that much fun for the guy to plea bargain and then go to jail. You know, the guy makes a good bust, and he arrests somebody, and they go, you know, I don't want to go to trial. They'll probably throw the book at me, so I'll just plea bargain down. And this is one of the reasons we're going to talk about. We talked about rape before. One of the problems with rape is it's usually there's only two people involved in a rape case. So it's usually what they will have to do is they'll have to plea bargain. If they have any evidence and the evidence is any good, sometimes they will charge them with assault and they'll charge them with rape, and then they'll plea bargain it down to, sadly, a lot of times they will plea bargain it down to a simple assault, unfortunately, instead of rape. Of course, if they plea bargain, if they are convicted of rape, or if they admit to rape, then they go on that list, the sex offenders list, and that's not a good thing. Most people want to stay off that list because they'll never be elected to Congress if they're on that list. Or maybe they will, I don't know. We're in a really strange place right now. Plea bargaining is a process in which the defendant agrees to plead guilty in exchange for some concession from the prosecutor. It's usually a reduction in the type of charge, the number of charges, or in the recommended sentence. When I was in the military, this was very common for somebody who was caught with somebody else's wife. They charged them with as many things as they could possibly come up with. And usually it was so that they could plea bargain down. So they catch somebody with somebody's wife, so it's adultery. It's also fornication. If one of them's not married, it's fornication. And then they'd also charge them with some other type of thing that I don't want to talk about right now. Anyway, so then they plea bargain, and when they plea bargained, they would throw out the sodomy charge, they'd throw out the fornication charge, and they just charge them with adultery. So that's, and
So pretty much they accuse them with the act but not the intent.
the act and not the intent. Well, they had all of these things, and they, yeah.
Okay, so that's what keeps them off the sexual offender registration.
Well,
list?
it's adultery. It's not, they wouldn't put them on a sex offender list anyway. They just lose a strike. Just one strike. But if they charge them with all three, they lose all their strikes. They lose all their strikes. Of course, if they're an officer and they get charged with anything, they kick them out of the service. Yeah.
So how do you know they're not going to do it again? Just kidding. I'm just
If they're not in the service, who cares?
Right?
They're not in our jurisdiction anymore. So a lot of times they'll charge them with several things, and we hear this. They'll charge them with assault. They'll charge them with rape. I guess if we want to use that case, or if somebody attacks somebody, they'll charge them with assault. They'll charge them with intent to kill. They'll charge them with attacking them with a deadly weapon. So they'll charge them with three things, and then they'll plea down to one thing. So at least they get a conviction. By pleading guilty, defendants give up their right to a trial. Most civil cases are resolved without a trial in a process called settlement negotiation. So if it's a civil case, it usually doesn't have to do with anything criminal. And this is how Donald Trump has gotten away with not being convicted of anything. One of the things that he's accused of very frequently is not paying for the stuff that he gets. But what he will usually do is plea bargain. It's a civil case. It's not a criminal case, it's a civil case, and since it's a civil case, they will go into settlement negotiation, and whatever they come up with, yeah, he claims victory. He has just claimed victory in the Stormy Daniels case. Stormy Daniels accused him of fraud because he didn't sign his name to whatever form, non-disclosure form. So she was, that case has been thrown out of court now, and he's claiming, and she has to pay his lawyer fee, which is kind of interesting. But it's a settlement negotiation, and since he didn't have to admit that he had ever had an affair with her, and he's claiming victory, of course. But it's a settlement negotiation. It's a civil case, so it doesn't have anything to do with the criminal investigation. And that was the deal with Kavanaugh. If Kavanaugh really did sexually assault, allegedly assaulted Christine Blasey Ford, that's a criminal case. But the statute of limitations has run out in Maryland, because it happened in Maryland. So if he admitted that he actually sexually assaulted her, well, they would have had to have taken it to court. But the statute of limitations has run out, so they can't. I mean, it's 35 years ago, so you can't. Well, not in Maryland anyway. Statute of limitations ran out, and that was one of the problems with Bill Cosby. Bill Cosby had been accused of sexually molesting all these women, but he did it in Pennsylvania and New York. In Pennsylvania and New York, the statute of limitations runs out after 10 years. So the only person that could actually accuse him and take him to court was the one lady that was molested 8 years ago. She was the only one, as odd as that sounds. But all those women came forward and said, yeah, he did this to me too. But of course they couldn't take him to court because statute of limitations had already run out. As strange and sad as that is. If the police believe that a suspect committed a crime, they will probably arrest the suspect. Charging implies a formal decision to continue with the prosecution, and that decision is made by the prosecuting attorney rather than the police. Police can arrest anybody they want, but the prosecuting attorney has to decide whether they're going to be kept. The prosecuting attorney has to decide whether they're going to charge them with anything. Police don't charge anybody with anything. They make accusations, and the prosecuting attorney decides whether he will accept those accusations. Drunk driving. I'm sorry?
With PI being one of the things, like they can be arrested for PI, but then could get charged for something they don't know.
PI doesn't
fall under that.
what is PI?
Public
Oh, public intoxication. Okay.
Like if they found any paraphernalia on them, but didn't charge them with it then and there, but then later on.
Okay, so the police arrest somebody and...
I'm just saying because it's more common because of college students.
Right, so you're talking about public intoxication. Did you take the breathalyzer test? Or did you refuse the breathalyzer?
And that would be a part of it?
Yeah, oh sure.
Huh. What if there was...
Well,
no?
we needed proof. We needed proof, and we need proof right away. So if you agree to take the breathalyzer test and you blow higher than 0.8, now we know, yeah. We
I'm
know
just
that you
asking
were.
because there was an incident recently on campus. It didn't sound like that, and there was no breathalyzer test taken of that student.
But he was accused of public intoxication with no proof of public
Yeah,
intoxication.
and then taken him, and then they charged him with possession.
They charged him with possession of paraphernalia?
No, of alcohol.
Okay, because
it was
alcohol is
just-
illegal on campus.
Yeah.
Okay. Did he have alcohol? Did he have a bottle? Did he have
No,
a
he
beer?
didn't have anything on him. He had a backpack, but I guess when they took him in, that's where they found it. It was in the backpack,
In the backpack,
and there was only one can.
of beer.
Yeah. Not
Yes.
open.
Still possession.
Yeah.
It's illegal. On the reservation, isn't it?
Mhm.
Beer is illegal. Okay. So he had a can of beer here on the
12
reservation.
ounces.
Yeah, okay, well, that's illegal. and once they arrested him for public intoxication, now they can,
Do whatever.
yeah, they have to confiscate all of the material that they arrest him with.
Mm-hmm.
Okay. And the beer was in his backpack.
Mm-hmm.
Yeah, they can do that.
Okay, yeah, because he was wondering about that, I'm like, I don't know, I think they do that. I was like, we're the Reds, pretty much anything is against you here.
Well, yeah, where did they take him? Is there a jail anywhere close to here?
Chinley.
Chinley's got a jail? Okay, I didn't know.
Chinley's got one, Winter Rock's got one.
There you go. I don't.
It's by the school, isn't it?
I've never, it's by the school, perfect place for
Is it by the
Right?
the jail, is by the school.
school? It's the one, the dirt road toward the fairground?
I can't be arrested on the reservation, it's kind of exciting.
I know.
But I can, of course, if
It's like by
if they stop me,
elementary
they can call the
Federal.
state cops. And state cops will come pick me up.
Then like by an elementary school?
I think it is.
Yeah.
The Fourth Amendment to the United States Constitution requires that any person arrested be brought before a judge within 48 hours of arrest. And that's federal. So they have to decide what they're going to do with you for within 48 hours. This is one of the reasons why if you're watching a television show, they can only hold somebody for 48 hours before they have to let them go. If they don't have the evidence, if they don't have any evidence, and they arrest them, remember, it's the district attorney that has to decide whether they're going to be charged with something. And they have 48 hours to produce all of this evidence so that the prosecuting attorney will decide whether they need to hold them or not. And of course, at that point, the prosecuting attorney is going to present the case to the judge, and the judge has to decide whether there's enough evidence to maintain the charge. The judge reviews the evidence summarized by the prosecutor and determines whether there is a reason to believe that the suspect committed the crimes charged. If it's speeding, of course, that's relatively easy. They've got the affidavit from the policemen who were following them or gunned them, and of course they have that information. Of course, you're not going to arrest somebody for speeding unless it's speeding that endangers other people.
Yeah.
Okay. So if you're driving, if you're driving 80 miles an hour in a residential area, then that's endangering other individuals. So that individual could be arrested. But if you're just speeding down 80, you're going 90 in a 75 on 80. Isn't it 80? No, it's 40. I'm sorry. I'm in the wrong state. It's 80. It's 80 up in Iowa. Okay. If you're driving 90 miles an hour in a 75 mile an hour zone, that's really not endangering because there's nobody on. There's only other cars on the road. So it's not really that kind of endangering. So they'd only give you a ticket. They would not take you to jail, probably. If you're driving at a really high rate, like 100, 110 miles an hour, then they'd probably arrest you. The judge will inform defendants of the charges against them, inform them of their constitutional rights, review the issue of bail, and appoint attorneys for those who cannot afford to hire their own. That's part of Miranda, is that if you can't afford an attorney, one will be provided for you by the state. The prosecution must offer some evidence on every element of the crime charged, and the judge must decide whether the evidence is sufficient to pursue the case further. No jury is present, and defendants rarely testify or offer any evidence of their own. If you watch, of course I only get New Mexico television, so we get to see these people being brought before the judge all the time. Normally in New Mexico, they don't actually go to court. They stay in the jail, and it's closed circuit television. So we get to watch them on closed circuit television, and they charge them. And they usually plead not guilty. If you plead guilty, it's all over. There is no trial. You pled guilty, therefore the judge will, at some point, they will decide what to do with you. The judge will sometimes send the case to a grand jury or reduce the charges, either because he or she believes the evidence does not support the level of crime charged by the prosecutor, or because of a plea bargain. And normally, this is what happens. So this is one of the reasons why the police have to do everything by the book. If they don't do everything by the book, then they have to throw that piece of evidence out. If the evidence doesn't, if they charge them with murder and there's no evidence that the person pulled the trigger, then the judge will just let them go. They don't really have a choice. If the evidence doesn't support what the police are accusing the individual of, and the prosecuting attorney doesn't accept it, then of course they're going to throw the case out. So the more that they see this, the more that the prosecuting attorney and the judge see the police arresting people and holding them for 24 hours or 48 hours with no evidence, the more they see this, of course, the more that everybody gets upset. And then the police are more likely to lose their jobs because they are arresting people frivolously without evidence. So you have to have evidence. Popular Penn State coach Jerry Sandusky was able to avoid prosecution in Happy Valley until a 2-year grand jury investigation. He was charged with 52 counts of deviant sexual intercourse, endangering the welfare of a child, indecent assault, the rape of several young boys between 1994 and 2009. He is now serving a 30 to 60-year sentence. So why wasn't he brought to trial before? Because the evidence wasn't strong enough to bring him to trial. But they had evidence that, they had some evidence that he had committed these crimes 52 times before they finally brought him to trial. Yeah. Well, there were some people that were hiding what he was doing, unfortunately. And eventually, of course, the grand jury saw the evidence, and they said that the evidence is strong enough to convict, and of course now he will die in jail. Probably he will die in jail. Since he's not that young, he will probably not survive his jail time. The grand jury consists of citizens drawn from the community. The grand jury meets in private with the prosecutor to investigate criminal activity and return indictments. Indictments are complaints prepared by the prosecutor describing the crime charged. Now, a case can go to grand jury and it can be thrown out. There's not enough evidence. The evidence isn't strong enough to convict, so the grand jury will throw the charge out. And this happens all the time. Usually it doesn't have to do with, usually has to do with criminal cases, but sometimes in a murder case, of course, there's just not enough evidence. We see a lot of cases where it goes to the grand jury if it's a fraud case. So they have to decide whether there's enough evidence to convict. In fraud, in RICO cases, which is another type of fraud. So all of that stuff has to go to a grand jury. The grand jury may call witnesses if it is dissatisfied with the witnesses presented by the prosecutor. In some states, the defendant has a right to testify in a grand jury case. But not all, but on all states. In some states like California. This is the reason why it seems like if you are going to a grand jury that you don't have a right to testify. Because in California you can't. They don't. So where do we get most of our television? Where is most of our television made? Well, it's made in California, of course, in Hollywood. So we don't get to see this. But in Pennsylvania and New York, somebody that's accused and goes before the grand jury is able to testify. In about 1/3 of the states, a criminal defendant cannot be prosecuted unless a grand jury has found grounds to do so. And a lot of these states are in the South, and since the grand jury has to bring charges against the individual, a lot of times individuals will go free for a number of months or years before the grand jury will actually bring them to trial. The remaining states permit the prosecutor to proceed either by grand jury indictment or by preliminary hearing. The grand jury decides there is sufficient evidence to justify the defendant being tried, If that is the case, it issues an indictment, and of course, then they go to trial. This is one of the reasons why the civil rights cases in the South took so long to prosecute. There was the case of the little girls, the 5 little girls that died in the bomb blast in Birmingham, Alabama. It took years before that case ever came to trial. The cases of the murdered freedom riders in Mississippi, it took years for them to ever come to trial. And it was because of the problem with grand juries. The grand jury didn't see adequate evidence to indict. So eventually these cases were tried by the federal government. A loss of civil rights is what they charged them with, because as far as the grand jury in Mississippi and Alabama were concerned, there wasn't enough evidence to convict. So they kept putting it off and putting it off and putting it off until the federal government went down and they said, well, you have impugned their civil rights, therefore they have the right to go to trial. And they were convicted. But then again, if you're convicted of interfering with somebody's civil rights, how long do you go to jail? Not for life, that's for sure. They only went to jail for 4 or 5 years. Later on, the criminal charges, after a more liberal grand jury was seated, then they were all indicted of murder and whatnot. One of the cases was just heard a couple of years ago. The case of this was in 1959. They blew up the Baptist church in Birmingham. There were 5 little black girls that were killed. One of these cases, it took almost 50 years for them to, well, it took more than 50 years, 55 years for them to prosecute one of the individuals. All the other people were dead, the ones that planted the bombs. Arraignment. At the arraignment, the judge makes sure that the defendant has an attorney. The defendant is asked to plead guilty or not guilty. It is customary for defendants to plead not guilty at this time in order to provide opportunities both for discovery, the defendant's attorney can review some of the evidence against the defendant, and for plea bargaining. And that's the reason why they never plead guilty. If they plead guilty, it's all over with. Then the judge decides what's going to happen next. But if they plead not guilty, even if all the evidence screams that they are guilty, the Parkland shooter pled not guilty, despite the fact that they had all this evidence that he shot the 17 people. He still pled not guilty. And the reason is so that his defense attorney can see what evidence they have against him. And it also gives him an opportunity to plea bargain. There was a mass murderer that plea bargained down to life. Was it the guy in Aurora? No. Was it? Yeah, it was him. Yeah, I mean, it was obvious that it was him. He shot up the theater, then he walked outside and he stood beside his car. He had thrown down his, he had an AR-15, and he had thrown it down in the theater, and he had a shotgun on his hip, and he still had the shotgun with him, and he was still in all of his armor. So it was fairly obvious that he was the guilty party, but he pled not guilty, of course. And eventually, of course, he was able to plea bargain down for a life sentence rather than the death penalty. Defendants and their attorneys want to be aware of the evidence the prosecution will use to prove its case. Civil cases, each side is entitled to discovery. Each side can question the other side's witnesses and review documents that the other side might use at trial. So in a civil case, everybody gets the same information. No surprises, no Perry Mason. Criminal cases, what the prosecution must reveal to the defense varies. Most states require only that the prosecutor share evidence that is exculpatory, that tends to show the defendant is not guilty or suggest that prosecution witnesses are not credible. And that's exculpatory evidence. So in some states, they have to show only exculpatory evidence, evidence that would show that the guy didn't actually commit the crime. In many states, the defense is required to notify the prosecution if it intends to rely on insanity or alibi defenses, if the guy has an alibi. But it all depends on the state. This is one of the reasons why if you get a law degree, you can't practice in every state of the union, because every state has different laws. So where did their laws come from, and why in the world do they have different laws? Why don't we all just have the California laws? That would make it easy. You could just watch television, figure out how to be a lawyer. Why do states have different laws? Because they have different ideas, I guess. Yeah, well, yeah, potentially. Yeah. Potentially. Timothy Masters was just 15 years old when the body of a 37-year-old female was found near his trailer park in Fort Collins. Timothy allowed police to search his room and school locker, and they found 2,200 pages of violently misogynistic writings and drawings and a collection of knives. No physical evidence was ever linked to Masters at the crime scene. Only 2,200 pages of violently misogynistic writings and knives. At trial, an expert witness, forensic psychologist, concluded, without having ever spoken with Masters, that some of the drawings represented Masters reliving the crime. Although some of the jurors had doubts about his guilt, they convicted him based on his drawings and his writings, that he hated women. And he had pictures of women being decapitated and being stabbed in the chest. That's the lady that was murdered, and that's Masters at 15. He's only a 15-year-old boy. These are some of the some of the pictures. There's a machete for you. That's what a machete looks like. And here he is with a sword chopping somebody in half. You see that on movies all the time. These are scary doodles that he made during the trial. I know. Masters was released from prison after 9 years when DNA evidence exonerated him. A review of the case showed that investigators had a second suspect and suppressed evidence to ensure the conviction. The prosecutor had colluded with the investigators for the conviction. He lost his law degree. He lost his license to practice law, a prosecutor. So the problem is, a lot of times that police are myopic. They find a suspect, they like the suspect, they want that damn suspect, you bet. So they stop looking for anybody else that might be the criminal. And in this case, they colluded to suppress that information, that there was a second suspect. Potentially it was a suspect that they had better evidence against. Can you convict somebody because of their thoughts? Or can you?
Yes.
Let's assume that I go back to Indiana and somebody shoots me with a deer rifle. I already told you that there's a guy that has threatened to shoot me with a deer rifle. So what if I get shot and killed in Indiana?
We'd all go over there and hunt that guy down for you.
That may be true, but he may not have been the one to shoot me. It might have been somebody else.
I'll get my opic and be like, you're the one.
First, take
Heard
your
that
laptop.
voicemail.
Well, and
Hunt that guy down. Just kidding.
I had a message, and it was 3 gunshots. Of course, I keep accusing Sharon, but I don't know. It sounded like a Glock 11. Yeah, there she goes. Uh-oh. Oh, I just said the word Glock 11. Did you see her face?
Yes and no.
A Glock 11 doesn't have a safety, so be careful, Sharon. That thing will just go off in your hand. I'm kidding. She doesn't have a Glock 11. Those things cost like $5,000. During the discovery phase of the case, both sides filed pretrial motions seeking favorable rulings in the admissibility of evidence like motion for separate trials, motion to sever counts, motion for charge of venue, motion to suppress a confession or other statements by the defendant, motions in limina, a request for a pretrial ruling. And that is what in limina means. One of the things you're going to notice is that when we start looking at even anything that has to do with the law, a lot of the terms are in Latin. So if you speak Latin, you're okay, but if you don't speak Latin, nobody studies Latin anymore. If you don't speak Latin, of course, you have to learn what these things mean. In limina means pretrial. It's a request for a pretrial ruling. In limina. I'm trying to think what it means. Now my Latin is fleeing me. When there are two defendants, often one of the defendants will seek a separate trial for fear that being tied together will result in a prejudicial decision. Timothy McVeigh and Terry Nichols, involved in the Oklahoma City bombing that killed 168 people, were tried separately. That was mainly because Terry Nichols, Timothy McVeigh put his bomb together at Terry Nichols' house, in his garage. Terry Nichols knew all about the bomb. They were both anti-government terrorists. There was a lot going on at that time.
Was that 95?
Yeah. Wait a minute. When did I go to Japan? 94. And I came back in 95. See, we went to Japan from Oklahoma City. So
Hey.
I know, I was in Oklahoma City in 1994. We came back from Japan in April of 95, and that's when the bombing was.
Mm-hmm.
Yeah.
I was in 5th grade when I saw that.
You were in the 6th grade and I
Yeah.
was in Japan. Okay, well that's interesting. So I had been working in medicine for 4 years.
5th graders shouldn't even be paying attention.
You're such a youngster. Or either that or I'm old. That can't be it. It must be that she's so young. Okay. The funny thing was that I'd been working in medicine for 4 years in Oklahoma City. And I went to Japan when I came back. They had the bombing, and so I got to see all my friends on television. They were the EMT people and the doctors and the nurses were all running around trying to save the 168 people. I don't know if you remember this, but the building, thank God you don't remember, because the building on the bottom level was a nursery, and it had pancaked down, and all these cement layers had come down. And they were able to save some of the kids in the bottom. It was ugly, and they were crawling in there, and they were digging around, and things were shifting around. It was a mess. Anyway, so Timothy McVeigh's the one that exploded the bomb. Terry Nichols was the guy that
Facilitated the place.
he did. He had a place, but this was in Oklahoma City, and the reason that they exploded the bomb in Oklahoma City was because Oklahoma City was very revolutionary at the time. They were very anti-government. Well, who was president in 1995? It was Bill Clinton. Slick Willie, they called him. All this crazy stuff was going on, and Rush Limbaugh was screaming for revolution. I know. There was all kinds of horrible stuff going on.
Now I'm all thinking like the way I think, I'm like, oh, those are my influences. I get it.
Exactly. So these people thought that they could start a revolution in Oklahoma City. I mean, the best place in the world. Oklahoma, they used to play Rush Limbaugh 3 times a day. His radio programs 3 times a day. It was nuts. I lived there, let me tell you. So there was a lot of crazy stuff going on. But they thought the revolution was going to start that day, the day he exploded the bomb. So they would have been free and clear. McVeigh, of course, was executed for his crimes by the federal government. Federal government very rarely executes anybody, and Terry Nichols has gone to jail forever. And you know how the federal government paroles people. They don't. Ever. Release released on good behavior doesn't exist as far as the feds are concerned. If a defendant is charged with multiple counts, they may choose to separate the charges and be tried in separate trials for each charge. This is a good example is Paul Manafort. Paul Manafort has been charged with just a ton of different things. I think it's like 15 or 18 counts. So he's had one trial in one jurisdiction, and now he's going to have his federal trial. He's been tried in Virginia for fraud and other things, and he's been convicted. Now he's going to have to go to federal court and face charges. But he's done something, hasn't he? He's agreed to help the federal prosecution. He's agreed to help the Mueller investigation. So that should help him in his next prosecution. So we'll see what happens. I keep saying that. I'm sorry, I don't mean to. This is Legs, this is MD, this is Sever, and this is Thor. I don't know. If a defendant is charged with multiple counts, they may choose to separate the charges. They may reduce the prejudice created by some of the more onerous charges. They will also get separate juries, of course. And every time you get a jury, you never know whether you're getting a good jury or a bad jury. If you get a bad jury, and you're prosecuted on all charges, you may lose your shirt and go to jail for a really, really long time. So they separate the charges, hoping that maybe they will get a good jury at some point and not have to go to jail for an extended length of time. Excuse me. The defendant may request a change of venue, moving the proceedings to another location on the grounds that community opinion, usually the product of prejudicial pretrial publicity, makes it impossible to seat a fair-minded jury. This is what happened with Paul Manafort. He was charged in Alexandria. Alexandria is right next to Washington, D.C. So potentially he was going to be tried in almost exactly the same place. Once on the Virginia side, and then once in Washington, D.C. So he tried to get the venue changed. He tried to get it changed to downstate Virginia. Downstate Virginia is very conservative. So potentially they would have seated a jury that was more favorable to what he had done if they had allowed the change of venue, if they had allowed him to move it to downstate Virginia. Now he made a claim that he couldn't get a fair trial in Alexandria. They said it was dangerous for him because people were, sending him letters saying, I'm going to chop your head off and things like that. So he wanted to change. He wanted to go to jail someplace else, and they allowed him to do that. They actually moved him 100 miles down the road, and they sent him to prison down the road. Unfortunately, the prison down the road wasn't nearly as nice as the one in Alexandria. Anyway, he's still in prison. Obviously, he's still in prison. He was convicted of 8 of 18 charges. So now he has to go to federal court, and he will go to federal court in Washington, D.C. Psychologists are sometimes involved in analyzing the extent and impact of publicity on prospective jurors. Of course, this is, if you've ever watched Bull on television, and I don't suggest that you do, but that is a story written by, it's not actually a story, this was Dr. Phil's life before he became Oprah's psychologist. He was a jury consultant. Phil McGraw, that was what he did. I know, it's weird.
I thought he was always an electrician.
No, he's a jerk from Arkansas. It's funny.
My daughter used to like to watch Dr. Phil when she was a baby, like 3 years old. I don't know what it was.
Must have been
She knew what time it was, and she'd be like, Dr. Phil's coming on. And I'll run all the way from her bedroom, go to the TV and put it on Dr. Phil and sit there. I'm like, what are you watching, kid?
It's horrible. Dr. Phil can cure you in 30 minutes.
Yeah, right.
I know, it's amazing. Or 15, depending on how many guests he has that day. The Fifth and Sixth Amendment protects Americans from self-incrimination and the use of statements taken without benefit of counsel. Often a motion will be filed to suppress statements made by the defendant, including a confession that a judge will have to rule on before a trial can proceed. And of course, that has to do with suppressing select pieces of information. And that's the Fifth and Sixth Amendment. You cannot, they can't force you to incriminate yourself. You can plead the Fifth. And if you plead the Fifth, it means I refuse to answer on the grounds that it may tend to incriminate me. I did it, I'm a bad boy, but I'm not going to tell you that I'm a bad boy. I'm not going to incriminate myself. I won't admit it so you don't have proof. And actually, we see that a lot in federal trials. Yeah. Pleading the Fifth. Motions in limina at the start, I'm sorry, that's what in limina means. At the start. Are merely pretrial motions that set limits on what evidence will be allowed during proceedings. While these motions are usually filed by the defendant to suppress select pieces of information, they are also used by prosecutors to determine the range of acceptable evidence. So they have a big pile of evidence, and the defense wants as much of that evidence thrown out as possible. So they will file briefs trying to get the evidence suppressed. He confessed. We want that thrown out because it was a coerced confession. We want that thrown out. So the defense attorney will try to get as much evidence thrown out as possible. And sometimes the prosecuting attorney will try to suppress select evidence to see how far the judge will go, how the judge is thinking. It's all up to the judge. The judge can decide that this piece of evidence is good and that piece of evidence is bad. But remember, the judge is not absolute. And the reason he's not absolute is because if the judge decides that this piece of evidence can be used and they appeal it, then the appeal court may decide that that piece of evidence should not have been allowed in the trial. And then they'll get a new trial. This is all very, very expensive. Trials are not cheap. They're really relatively expensive. So the federal government or the state government doesn't want to do this over and over and over again because it's too damn expensive. So they will try to have only one case. A lot of times when it comes up the second time, they'll just throw it out of court. And they'll just let the guy go. Because it's too expensive. They don't want to prosecute. It's too much trouble. How much are they going to recover from this? How much money are they going to get from this? Well, they can charge him for, I don't know, what, AT&T. These cases where they take a corporation to trial, a lot of times the rewards are a percentage of what actually was being stolen or being ripped off. Did I tell you my AT&T story? Once upon a time in the United States, AT&T did not service military installations. Military installations were being serviced by small telephone companies. AT&T owned all the long-distance lines.
Oh, hey.
Okay. So in order to connect to a long-distance line, you had to pay a connection fee. Okay. So every time if we're dealing with a different telephone company, you have to pay. Not only are you paying 30 cents a minute or whatever it was, but you're also paying a connection charge. So all these military at all these military installations, AT&T was making buku dollars. They were ripping off the federal government big time because they didn't have any telephone companies that serviced military installations. And this was during the Cold War, so we had millions of men in uniform. We were drafting people, and so we had all of these bases all over the world, and none of them were being serviced by AT&T. So in the 1970s, in 1973, my wife left, and she went back to Indiana. And she kept calling me collect. She kept calling me collect. And of course, I was on the Air Force base, so all of those, every time she called me, there was a connection. Not only was it that I have to pay 30 cents a minute, but I also had to pay a connection charge every time she called me. So every time she got drunk, she would call me on the telephone and stay on the telephone. You know how drunk people are. You can't get them off the phone. And it wouldn't do any good to hang up because the connection was still there. So sometimes, even if I hung up on her, I was still, as long as her telephone was off the hook. I know. I had a bill one month for $1,200, a telephone bill for $1,200. I made like $5,000 a year, and I got a telephone bill of $1,200. Anyway, so, and if you don't pay your bills and you're in the military, they'll garnish your wages, like right away. And the one company that could get them to garnish your wages almost instantaneously was AT&T. It was a huge ripoff. So they took AT&T to court. It was a class action suit. It wasn't just me, it was everybody. I mean, it was like 1 million Army guys are trying to get their money back from AT&T or get their bills reduced. That's all they wanted to do, was get their bills reduced. And this is during the Vietnam War. Okay, so they go to court. And of course, all of this stuff is taking place. And all of this stuff is taking years for them to decide. So for most of the people in the suit were out of the military by the time they decided the case. But they didn't decide the case for 15 years. It took them 15 years for them, for all this discovery, for all this stuff to go to court. By the time they settled, and they did settle, AT&T did settle, we're talking billions and billions of dollars. But we're also talking about the federal government, we're also talking about AT&T, we're also talking about a monopoly. They were charged with a monopoly. That's when AT&T actually became AT&T, because AT&T had to break up. It used to be Bell Telephone, and they used to own all the telephones in the United States. If you had a telephone that connected to a long-distance AT&T line, it had to be a Western Electric telephone. Are you getting the picture here? All right. So yeah, it was a monopoly. So they decided it was a monopoly, so they busted them up. And at that point, instead of us suing Bell Telephone, which doesn't exist anymore, we had to sue Bell South. Right? Right. Okay, so remember, it took 15 years for them to decide, oh, wait a minute, we need to bust up Bell Telephone. So all of a sudden, it all started all over again. Yeah, exactly. So we had to sue Bell South because I was living in Lubbock, Texas at the time. I paid my bill. I went ahead and paid that $1,200. The way I did it was I re-enlisted. You got a $10,000 re-enlistment bonus. But I had to do that in order to pay my telephone bill.
That's like my uncle, when he divorced, he paid for all his wife's debts. And I was like, dude.
I also had to pay my wife $5,000 in order to get her to not contest the divorce.
Yeah. That's what my uncle had to do too.
And because she didn't contest the divorce, I got the kids. And that was all I wanted to begin with, was my kids. So it cost me $5,000. But I was able to pay off my Bell Telephone bill. Anyway, my AT&T bill. They finally settled the case, and they paid like 0.3 cents per dollar. Remember, it was billions and billions of dollars. So I got a check for $200. Yeah.
It's like with the whole Wells Fargo thing that just happened recently, with them opening up bogus accounts for everyone, and they opened up, I guess, under one of my names, and I got a check back, and guess how much it was?
Pennies.
$4.23.
they're in trouble again.
They're in trouble again for the
They're-
exact same thing again.
Exactly, they're in trouble again.
So I'm like waiting for another check. So I was like, hey, $7. That's $10 this time.
No, that's not even a Whopper. That's really tragic.
Barely even a
I know.
Happy Meal.
Pennies on the dollar. Most of the people didn't get a check at all.
Yeah.
Yeah. Well,
So I know when my mom had that check, she's like, I didn't know that was going on. She's like, open it, it's probably a big check. I'm like, yeah, it's real heavy, Mom.
we're dollars and 23 cents.
Come on.
So the deal is that a judge has to decide whether somebody has to stay in jail or not. Somebody was just denied bail. No, it was $1 million bail. Who was it? The bail was a big deal. It was a big deal. So they put a $1 million bail. Well, you have to pay 10%. So $1 million bail is $100,000. You have to have $100,000 cash in order to keep them out of jail. Judges must decide whether to keep criminal defendants in custody between arrest and trial, or whether to release them with a promise to reappear for later hearings. Judges can deny bail if a defendant is a flight risk. They can require the money to be deposited with the court. Can use a bail bondsman. They can require a third person to be responsible for the defendant's future appearances, forfeit the money if the defendant doesn't appear. And that's what usually happens. 48. 48. I got 48.
Okay.
Anyway, let's stop right now. Anyway, we're done. My AT&T story made me want to cry.